Do you want to know the differences between a request for arbitration and a statement of claim? Don't go anywhere, 2 seconds, and we jump into the differences. Hello everyone, my name is Maria Rubert, lawyer and arbitrator with a base in Dubai in the UAE for the past 15 years. I'm happy to be with all of you today to talk about my true passion, which is namely arbitration, commercial arbitration. If you've seen my earlier videos, you will know by now that arbitration is an alternative dispute resolution method that helps avoiding national state courts when avoiding them may be the right option for the given dispute or for a potential dispute in the future. If you do business in a foreign jurisdiction that works in a different language, arbitration may be an automatic at least option to think about. So now, if you already know about arbitration, if you are watching this video, either you are considering arbitration, you may be considering arbitration, you are perhaps doing a contract, starting negotiations with a company in a foreign jurisdiction, you may be studying the law, you may be studying arbitration particularly. So I'm happy to give you this very practical information to differentiate two key documents in any given arbitration proceeding. So the request for arbitration. The request for arbitration is the document that starts the arbitration. It's the document that lets the arbitral institution, if there is one, because you could also have an ad hoc arbitration, but if you have an institutional arbitration, the request for arbitration will be letting the institution and the respondent or respondents know that they will have a case. Yes? So, as you can imagine, it takes place very early in the proceedings. It's the first step, the request. And actually, the request will be valid when it is complete. All institutions go over the content of the request for arbitration. In very brief, it's basic information. Who are you? Who is the other party or the other parties, and then the address, contact details, nationality of each one of you. Then also, why are you going to arbitration? Where is the arbitration agreement, which usually is within the framework of an agreement, of a contract. So you will need to include that document, and also the basic data. How many arbitrators do you want and why? Maybe the agreement says so. What is the language? What is your position in terms of the appointment of the arbitrators? Any characteristics that perhaps have been discussed by the parties? And if not, what is your position? Yes, what is a brief summary of the facts leading to the registration and an estimate of the claim amount? This will be very important for the institution because they will need to calculate the advance on costs. Yes? Actually, DIAC, the Dubai International Arbitration Center, all centers go over the content of the request for arbitration, but the DIAC particularly, I'm very happy with this institution. I got a cases arbitrator in the last few days, and we also, as a firm, we won an important case for one of our clients. So we are happy with DIAC. It's very used, I would say, is the leading arbitral institution when doing business in Dubai and in the UAE and the region, I would say. And the DIAC rules of 2022 go over the request for arbitration in its Article 4.1, and it actually, at least if you are starting, simple, you go to Article 4 and ensure that in your document you are including all the details that I have addressed, because this is very basic, we do it all the time. A request that the dispute be referred to arbitration, the full name, nationality, address and contact details, including telephone and email, a copy of the relevant agreement between the parties which contains the agreement to arbitrate. And then it says, interesting, if there is more than one agreement, you need to indicate as to which agreement to arbitrate each claim relates. So this is important as well, a brief description of the nature and circumstances of the dispute, a preliminary statement of the relief sought, an estimate of the sum, as we were saying, and the relevant concerning the arbitrator and their choice, also the relevant details as to the seat of arbitration, the language, etc. Yeah? Very simple. So this takes place before the arbitral tribunal is in place, and it goes over process, the procedural details, which will be very important for the arbitral institution. Now, what is the statement of claim? The statement of claim is the document that expands on the merits from the claimant's position, of course. Is the expanded version of the facts and legal arguments of the claimant. And this, usually not always, is submitted with an exception. You could file the request for arbitration and the statement of claim at the same time. And then when the time comes for the statement of claim, you could amend or not amend and resubmit. But usually in this part of the world, you submit a brief request for arbitration and then an extended statement of claim. The DIAC covers the statement of claim in its Article 24. In very brief tells you, if it has not been submitted before, because you could submit it with a request for arbitration, the statement of claim within the time limit determined by the tribunal after consultation with the parties, which usually takes place at the preliminary meeting, and afterwards there can be terms of reference can be drawn, or a procedural order. So usually you will know when you have to submit the statement of claim, because either there are terms of reference or a procedural order, or both. Yeah. So here the claimant will concentrate on the merits. So it will expand on the facts of the case, greater detail as to when and what happened, and also the legal documents, the legal arguments. Why what you're asking is legitimate to be asked in accordance with the law governing the case. Yes. Then usually at the preliminary meeting you will decide the extent of the content of the statement of claim. For example, if at the preliminary meeting you say that you will rely on expert evidence, the tribunal or the parties, the tribunal could order or the parties could agree that the statement of claim will include the expert report. Also, some arbitrations, parties agree that witness statements will also be submitted, although in this part of the world we tend to see more often that witness statements and expert reports are submitted at a later point in time after the statement of claim. So statement of claim, statement of defense, and then we jump into perhaps document production, then witness statements, and then hearing preparation, usually. So I hope that you have learned a little bit. As a brief summary of what we have covered, the request for arbitration is different from the statement of claim mainly because of the timing. Request for arbitration is filed at the very beginning of the arbitration before the case is transferred to the arbitral tribunal. The statement of claim is filed after the tribunal has taken over the process, and usually a preliminary meeting has taken place. Also, the level of detail. The request for arbitration concentrates on a summary of the facts and concentrates on the parts of the process that are important. Tribunal members, characteristics, any thoughts as to the appointments, language, seat of arbitration, governing law, details and description of the parties, and contact details. The statement of claim concentrates on the merits. Yes, so as we see, the purpose is different. Request for arbitration, letting the respondents and the institution know that an arbitration is starting, kicking off the arbitration, and the statement of claim explaining the arbitral tribunal why you should be the winning party, concentrating on the merits. So again, I hope that you have learned a little bit, that you have enjoyed the video. If so, please do like my video, please do subscribe to my channel to get to new information as soon as it is out, and also follow me on social media to get to know other areas of my day-to-day. Thank you very much for your loyalty and for watching my video. Thank you.